Good morning. Welcome back to the SME Show with me, Francois. I'm the host of the show, and I'm joined as always by experts in the fields that we want to talk about. And today we really want to talk about trusts. And as you'll see, we said, well, to trust or not. And I think we find in practice that a lot of business owners do have trusts, or they are considering getting a trust and putting things into trust. And I think during this pandemic and the lockdown and everything that's happening, people are again considering whether a trust is a good idea. And some people are very happy that they did have a trust, and other people are not so happy that they have a trust. So we thought, let's get into a discussion around trusts and really whether trust is still a good idea, whether it is really valuable, and if, it's something that you should consider. And also, what we'll definitely be talking about today is that, what are all the things all your ducks that needs to be in a row if you do have a trust, and that there's a better understanding around what is required. So with me today is obviously I've got again Ida. Ida, welcome back. I'm going to put you on the screen just now, and I've also got Wynand and Renate. So all of them, good morning. Welcome to all of you. Thank you very much for joining me. I really appreciate it. So let's start with you, Ida. Good morning, Ida.
Good morning. Good morning. How's everybody doing?
Hope
well.
Good.
Good stuff. And Wynand, you are a returning guest on the show, so welcome. Good morning to you.
Thank you, Francois. Thank you for the opportunity.
Nice. Love the shirt. I think it looks quite good. You're the best looking one here today. Sorry, ladies.
Oh, well.
Renate, good morning. Welcome. It's the first time you've been a guest on this particular show.
Yeah.
You've been a guest on my other show, but thank you very much for joining us today. And just maybe a brief background before I give you an opportunity to say hi. Renate is a trust administration expert, and she also understands the accounting part and everything around trust. So I thought who better to get in on the conversation than to invite you as well, Renate. So thank you for joining us.
Thanks, guys, and hello, everyone. Yes, thanks.
Awesomeness. So I want to get it off today. Let me just quickly get my own ducks in a row. Yeah. I want to talk about trust. So I guess the best place to start is maybe with you, Renate, is to ask the question. But why consider a trust? When is the trust a good idea?
Okay. So I think the first thing for me is there's a couple of reasons. The one would be if you have minor children and you want to make sure that they will be looked after. Also, when you may have a spouse or family members that are not really that au fait with managing money, running money, and you want to rather protect it and have people look after it for them. Then you also have the asset protection component. So when you are a business owner and you want to protect your assets, I think what one should stay away from is, as you always refer to it, the briefcase trusts, where it sounded like a good idea and you're going to put your teaspoons and toasters in that trust, and that's the only purpose of it. A trust is quite an expensive entity to run. You've got trustees fees, you've got accounting fees, you've got much higher tax rates. So you need to have a trust if you want to create a legacy, and if you want to protect your assets, or if you want to make sure that minors are going to be taken care of. So that's my view on when we should have a trust and when not.
Awesome. I like that. And Wynand, from a personal, sort of financial planning point of view, or even from a business planning point of view, what is your view on when is it a good idea to get a trust?
Thank you, Francois. Yes, a trust is a fantastic entity to use to protect assets and to separate certain risks from each other. But I think what Renate has said is quite true. It's not a set up and forget entity. We have seen quite a lot of those, or the briefcase trusts, as you mentioned. So I think for someone considering to set up a trust or trust structure, if there could be more than one trust in the structure, they have to understand that this is a long-term, it's a long-term project, and there are fees and professionals involved. And with the sort of legislation and tax legislation constantly changing, you need to have a team who can guide you through those changes. So, I think it's important to understand that it's probably not for everybody. And we are finding that it's more your high net worth individuals or individuals in business who can benefit from setting up such a structure.
Yeah. So, okay. So if we start there, I want to sort of get to the point where you've like I own things and I owe things. So in other words, I have assets and I have liabilities. And I guess there's sort of two portions to my life, and this is going to sound comical maybe in one way, but that there's sort of two things in my life that I need to consider. There's things that can go wrong, or things that can happen, or events that can occur while I'm alive. And then there's obviously my death and what happens after that. So where does the trust play a role in that, Wynand?
Yes. So assets and liabilities. So anyone who's alive will have some form of assets and some sort of liabilities. And if you imagine that your estate is hopefully going to grow at quite a good rate, and you would like to transfer as much of that growth and as much of those assets to the next generation as possible, especially if the costs are in line with what your expectations of growth are. So things that can go wrong potentially, whilst you're alive is, you might have creditors. So I think we've never been in a more exemplary time or where this is a really topical issue. We've seen very strong businesses go into business rescue. We've seen very strong businesses close their doors. And for those business owners, if they have at least safeguarded some of their personal assets and investments into a trust type of structure, that would at least give protection to those assets. So I think while we're alive, creditors probably is one of the biggest reasons. And it's not something that we can predict. No one could have said in January that we're going to be sitting in home incarceration still in May and unable to conduct business as per normal. So that would be one of the reasons that we're looking at, while we're alive, is to protect assets. And at death, there's a whole host of protective issues and also costs. So when you pass away, there's a process through which your assets are, accounted for. And by assets, we mean the house, the car, the business, the money in the bank, the investments. Plus, we're then talking about deemed assets. Deemed assets would be things like life insurance. So life insurance then suddenly, in a minute, becomes extremely valuable. And those assets are all, put into a bucket and counted and distributed. But before they can be distributed, there are certain fees payable, such as executors' fees, such as capital gains taxes and estate duty taxes. And by utilizing a trust, you could skip a lot of those fees, because there's no transfer of assets at death. So that is quite a worthwhile, subject to look into.
Yeah, and on that, Renate, I want to jump to you and ask you, so if we now decide to set up a trust, obviously you need to get advice and make sure that you are comfortable that you're doing the right thing for what it is that you need. But now if we set up this trust, there's two things I want to talk to you about. The one is, like, how do I get the assets into the trust? That's my first question.
Okay, so to get assets into a trust, you have basically the two ways. Is either you need to donate or sell those assets over to the trust. Alternatively, you would purchase it from outset in the trust. And you would do that, let's say, for instance, if you're purchasing a property in the trust, then you would secure the bond in the trust. You may donate some funds as a deposit to the trust, which would pay the deposit to the bank. So that would be buying assets in trust. It could also be where you have a multi-trust structure, or you may have a business already in trust which declares dividends, and you would use those dividend funds to then either invest or purchase assets. When we need to sell assets over to the trust or donate assets over to the trust, there is various legislation that we need to look at. So you could, for instance, trigger the 7C taxes on loan accounts. As you know, we've got our donations cap of 100,000 a year. So if we exceed that, we could trigger donations tax. And then, of course, there is the option of Section 42s, but you need to understand very clearly how that works, and it's not the go-to option. So really the two generals are the buy in trust with funds from trust, or otherwise sell or donate over to trust.
Okay, yeah, and then apart from that, the tax implication things that could be applicable there, I mean, I would guess that the best option would be to buy it from the onset in the trust, if that was possible.
Yes.
But the next question then is, okay, so now what happens? Because in practice, when I come across clients, I find a lot that they feel like it's their trust. So I created a trust, the Francois du Toit Family Trust, for example, and I own the trust. I can do with that trust. I control the trust. It's my trust. What is really the situation here with a trust? You know, when I create a trust and I transfer these assets to the trust, whether through donation or I sell it, or the trust goes and buys its own assets, you know, who owns those assets, and where does it leave me once I've done that?
So there you would have to look at whether it's a vesting trust or a discretionary trust. But really, at the end of the day, a trust is set up for the benefit of the beneficiaries. So although the trustees may feel that they own those assets, they do not. It is now signed over, either donated over or purchased directly in the trust. The trust should have an asset register, and these assets would be noted in the financial statements as well of the trust. So the role of the trustees, or maybe we should look at the three parties to a trust. There's the founder member, who's the party that decides to start up this trust, and there's normally a founder's fee or initial donation. And then there is the trustees, and those are really the people that need to manage the assets in the trust and the conduct the trust in a way where it is for the benefit of the beneficiaries. And then there are the beneficiaries that will benefit from this trust, either by means of it having a vested right or by means of discretion, where the trustees would exercise their discretion. But that is where we need to be very, very careful that once you have disposed your assets to that trust, you are merely there to manage those assets. And really, if you look at the trust legislation, it also says that you should operate that trust and the assets in that trust even better than your own assets, because you are doing it for and on behalf of those beneficiaries. So very clear there. And also it should be the consensus with trustees when you want to act. There should be resolutions. There should be minutes of meetings. There should be regular meetings where trustees would make decisions to the best interest of those beneficiaries. So it's not just willy-nilly do things, decide things, sign documents wherever you feel like it. It is actually a consultation process.
Yeah, and I mean, so what's really happening here is that one would need to understand that you are signing over ownership of those assets to the trust and actually to the trustees. The only thing is that those trustees, you can create a trust to protect your assets, you know, in the event of going insolvent, possibly, or for whatever reason. But at the end of the day, it's about the beneficiaries, and the trustees must always act in the best interest of those. So, I mean, we find a lot in practice where people are taking out policies and things like that in the name of the trust. So what they would often do, Wynand, if I can direct this question to you, is that I find that a lot of times people will take out a policy because that's one of the cheapest ways to provide capital in a trust. Now, I'm not going to get into the whole thing about, like, you have an inter vivos trust and you have a testamentary trust, and when should you do. And for whatever reason they created this trust, they sit with it, and now they decide that they need capital in that trust once they pass away. So then they take out a life insurance policy, you know, in the name, or the trust takes out that life insurance policy.
Benefits to having a trust-owned sort of life policy. Insurance contract, there can be up to 4 parties or even more. And in principle, there has to be an owner. So someone has to come up with the idea of taking out that life insurance policy. So someone has to physically own the contract and have the right to make decisions about, you know, whether to increase cover or decrease or claim or whatever, you know, to act with that policy as time goes by. So that's the owner. And I think what you're referring to now is where the trust is the owner of the policy. The second party is the payer. I mean, not necessarily in that order, but someone has to pay for the cover. And that could be, or hopefully would be, the trust. There could be a third party that pays for it. So we've come across cases where clients have set up a trust, but they never really set up a bank account for the trust. So they've taken out policies owned by the trust, but paid for by them. Now, even though that's not a, you know, it's not a criminal offense, it's not ideal. So someone has to pay for that cover. Thirdly, there needs to be a life assured. So someone's life needs to be insured. In other words, the trust insures the life of X, could be a trustee, could be a party to which the trust is connected. And that person is the one that's meant to, you know, stay alive for as long as possible. If not, then that policy becomes payable. And then lastly, there should be a beneficiary. So someone should benefit from the proceeds of that policy when it pays out. And normally that would be the trust. Normally, you would be able to appoint a beneficiary on the death benefits of a policy. So in other words, if their life assured passes away, that death benefit could be payable to the trust, or the trustees could say, you know what, let's get this payment made to the spouse. So that's a possibility. However, on the bulk, I would say disability, severe illness type of benefits, those would normally default to paying to the owner of the policy, which would be the trust. So it's important to note that. In other words, if you're going to take out a life assurance policy with life cover, disability, severe illness cover, etc., and that cover is paid into the trust, it's fine, as long as the trust deed allows for you to also still benefit from those payments. So if you're, very ill or become disabled and your insurance pays into the trust, the trustee should, in terms of the deed, be allowed to give you some of that money or cause you to benefit from it. So that's a very important thing to consider. We have come across a couple of horror stories in the last sort of 10 years where we've had clients claim on policies that were held by a trust, and they've had legitimate claims, and it's not the insurance companies that don't want to pay, but because of FICA, they can't just pay money willy-nilly anywhere. So when you find a situation like that, and there's a proper trust-owned policy, but the trust has no bank account, the trust deed is missing, the trustees don't even know that they're a trustee on the trust, and the claim can't proceed unless we have the deed of the trust, the authority letter from the master, the FICA of all the trustees and beneficiaries, then it becomes quite a big problem. So, fortunately, the incidences we've had, we've been able to solve. But if that trustee, were to pass away and we didn't have the correct person with the correct authority to sign off the changes needed in terms of the trust to bring it up to speed, that could be catastrophic. So it's definitely, it's a good thing to structure your policies and your cover and potentially even your assets correctly. But I think it's important to understand that it doesn't stop there. You have to have a team around you that can assist you and advise you going forward. And as things change, to advise you of what changes to make to stay compliant.
Yeah, and I think one of the worst horror stories that I've ever come across, Wynand, is where a policy was done. This is like a good few years ago. The policy was done in the name of the trust, but here's the thing, that trust was never registered.
True.
So there's no getting out of that. I don't know, that was, I don't even know what came of that at the end of the day. But I mean, that's the worst thing that I've come across, where people have said, we're starting this trust, we've done the paperwork. Yes, the copy of the deed is not been registered yet. But and I think that's also why companies have become so sticky to ask for these things up front when people are applying. Back in the day, they did not. And then you could just apply and there's the name and it would go through.
Yes. So I could tell you, we had an incident where a client fell ill. He had pancreatic cancer. And, obviously that's not, it's not a very long journey. And we started to put in claims towards disability, severe illness, etc. And it turned out that his trust structure was a complete mess. And the premiums were being paid from a CC, closed corporation, that he was running his business from. And, he was required to have a bank account in the trust for this benefit to be paid out, meaning the disability and the severe illness benefit, but he had no bank account. Eventually, the only way to do this was for the bank to send a representative to him at his, deathbed and open up an account into which these benefits could then be paid. Had that not been the case, it would have taken forever to sort this out. So, sure.
It's crazy.
There are some hair-raising stories. And I think that, the bottom line is it comes down to ownership. If you really think about the word ownership, what does it mean? If you own something, then it's yours to do with as you please. If your trust owns a table, a house, a car, a policy, then it belongs to the trust. It doesn't belong to you. You can't just carry on as though it were yours. You can make suggestions to the trustees, but if your trustees don't even know that they're trustees, it becomes very tricky.
And they're not allowed to if they don't know.
And just another thing is, a lot of people would try and set up a trust and put themselves and their wife down as the trustees, happy days, and maybe the neighbor. But what do they know about managing a trust? the Trust Property Control Act is, it's there to be understood and read. And that's why you need people to assist you with this. And that's why people often balk at the idea of paying for independent trustees and for specialist accounting. And that's par for the course. It needs to be done.
Yes. And then Renate, I want to get back to you. So Wynand has now mentioned quite a few times the trust deed. And what is this trust deed, and is it important? And if it's important, why is it important? What is this trust deed all about?
Okay. So the trust deed is really the contract that's sent to the Master of the High Court, and it is your conduct guide, for lack of a better expression. So the deeds, the purpose of a deed is to basically tell you who the trustees are, who the beneficiaries are, who's got what rights, who's supposed to do what, how do we resolve conflict. And yeah, I've been in trust since 2001, and I've literally, when people would come and see me, I've seen deeds that were like 5 pages that really didn't set out any of these rules and any of the conduct. So you actually don't know what's supposed to happen in that trust, or where you have testamentary trusts that were set up via testament, but the clauses were done so poorly that it's almost impossible to run that trust properly. So a decent trust deed should be updated regularly. You should be compliant with what is the Trust Legislation Act. And although the Trust Property Control Act hasn't changed in many, many years, it's more about the court cases won against the trusts. That's of importance. And it is where the tax legislation changes, or the tax rulings around trust change that you need to understand. So the trust deed is really your user manual for that trust. And the start of the process is that you would hopefully meet with someone that is a trust specialist, draft a proper trust deed that sets out all the requirements. That then gets submitted to the Master of the High Court, who will then issue a letter of authority. And that letter of authority is almost, for lack of a better expression, like your ID document of your trust. So that would give you your IT number, the trustees' details, the master's office where this trust was formed. And then with that is the trust deed. So that's really where the trust deed fits in.
Yeah, and also I want to add to this that a lot of people are under the misconception that a trust is a separate legal entity. It is not. It is a concept. It is something that it's a contract that is entered into between the founder or the creator of the trust and the trustees. And that whole document, that's what a trust is. A trust is not a separate entity or like a CC or a company. It's not. However, for tax purposes, it is. Yes. So from a tax point of view, they view it as a separate person, but in reality, it is not. It's come about through a contract that is entered into between the various parties. And then, I mean, from that trust point of view, I think from a trust deed point of view, one of the things that, and you've alluded to this already, is that the powers of the trustees are set out and should be set out in that trust deed. Now, you and I do a lot of audits on trust deeds to look at those trust deeds, because often, yes, one of the biggest issues, the trust deed or the trust was formed in the 90s or the early 2000s, and they've never been reviewed. They've never been, like, there were new court cases, there were new things that happened, things that was allowed before is not allowed anymore, or we thought it was going to be allowed, and now because of those court cases, we found like, no, in fact, it's not going to be allowed. And people don't update. They think they've got protection, which they actually don't. So when we look at those things, I think there's 2 things that one should need to consider. Well, 3 things, I suppose. But from what the trustees are allowed and not allowed to do is all of that must be in writing in the contract. Then often what we find in practice is that it's not always about what is in the trust deed. It's sometimes what is not in the trust deed. So what has been omitted, okay? Whether it's on purpose or just like we didn't think about that, So those kind of things. But what is important is that the trustees are not allowed to act outside of the powers that are given to them in the trust deed. Is that right?
100%. That is very important. And what I think trustees don't understand often is the severity of their role, because they carry the can. they can actually be taken to task by the beneficiaries. They will also have to, if you, for instance, want to acquire a bond in a trust to buy a property, the trustees would sign surety. Now, obviously, the independent trustee would not be held accountable for sureties, but the other trustees would. So you are held accountable. And when it comes to the tax returns of that trust and taxes due, the trustees, including the independent trustee, will be held accountable. So the roles of a trustee is not to be taken lightheartedly. It's a proper responsibility that you've got, and that's why it's so important that if you are going to have a trust and you are going to accept the responsibility as a trustee, that you make sure that if you are not a specialist in the field, that you do surround yourself with specialists, and that would be the independent trustee, which may be your accountant or your attorney, and definitely also to deal with accountants that understand trusts and how trusts fit together and the tax liabilities of the trusts.
Yes, because that becomes a real nice, interesting place to play is the tax side of stuff. So I'm not going to go there today. Ida, I want to come to you there and ask you, have you? I mean, what are the kind of compliance things that needs to be in place for a trust? So that we know that the trust stays compliant from a tax point of view and from an accounting point of view and from a from the master's point of view. Or what are the things that must be considered in terms of that? Well, what are the things that must be done every year?
Okay, so when we look at a trust, we try and look through it from a accounting perspective, a tax perspective, and an administrative perspective. Accounting perspective, we try and keep updated monthly accounts. If the trust in itself is VAT registered, that we ensure that the calculations and submissions and the payments of that is done. Then also that includes management accounts if that is required, and the final annual financial statements. Then from the annual financial statements, we have the taxation liabilities, where we have to submit income tax returns. We have to submit provisional tax returns every 6 months. We have to ensure that the trust in itself is always tax compliant. There's always a tax compliance certificate. And if there is any objections or disputes with SARS, that needs to be handled to ensure the compliance with SARS is always in place. And in today's age, I think tax compliance has become one of the quick words now that we use for everything, because everybody wants a tax clearance certificate when they look at you, when you're buying a property, a car. When you do anything, they now want a tax compliance certificate. And then from an administrative perspective, we try and but review and ensure everything is in place. The record of all the resolutions, the record of all minutes of the meetings, and the management of the trust in line with the trust deed, and the management of the trust in line with the current legislation, as Renate previously stated.
Yeah, because I think we find a lot in practice that, these things are not in place. So somebody decided they're going to buy a property because there's this big bargain that came up and everybody's so excited. So they purchase the property, or, they do things, or maybe they buy a new car or whatever in the name of the trust, and they go ahead without letting anybody know that that's what they're doing. And the problem is, because that is not part of the daily or monthly running of that trust, there needs to be a decision by the trustees, and that decision needs to be recorded in writing, and that is what's called a resolution. So those things are often missing, and then part of what we do in terms of the accountables when we look at that is to ask if there's any transactions that are not regular in nature. Then we would ask, where's the resolution, and help you get that in place. But Renate, why is that actually important to have that paper trail? I mean, is there have you seen some issues, but what makes that so important? Is that the requirement, or is it just nice to have?
So often when there is action taken against the trust, the first thing they'll ask for is your minute book. And your minute book would have all your minutes and all your resolutions in to confirm that decisions were passed by the trustees. Also, things that I saw when I had the accounting firms was literally, if you decide that you are now distributing profits to a beneficiary because you want to pay the lower tax. We've actually had where SARS called on the resolution that they wanted to see passed before the year end, to specifically state what the percentages were. Where was the decision passed prior to the actual passing of those benefits? So, for instance, 2 resolutions were actually required. One, where in, let's say, the beginning of the year, let's call it first week March, we agree that for this particular tax year, we will split the benefit in this trust, or the profits, whatever income, in this percentages or this particular way. So for argument's sake, we are going to split it in 4 equal quarters with 4 beneficiaries, or we're going to have a 50-50 split, or all profits will go to this particular party. When you're talking profits, it would be income and expenses. You can't just move the profits. But that was important. And then come year end, by 28 Feb, you would then have to pass a resolution to say, yes, we now are in line with the initial resolution, let's call it first week March. Last year, we are now in line with that, distributing the benefits as discussed. And then we also, as a safety precaution, we would then have an acceptance document. So where all beneficiaries that received anything from the trust we would draft it for those beneficiaries, and they'd have to sign it to say, yes, I acknowledge receipt of this benefit from the trust, whether it be interest, whether it be rental income, whatever it may be. And I acknowledge that I will declare this in my personal tax. And that was so important, because we had certain instances where if SARS saw that you didn't have these resolutions in place, they would just merely reverse that and tax it in the trust, and then charge you the understatement penalties because you didn't declare it in your trust income tax. Yeah. So those resolutions are really any document that the document that underpins any decision you make in that trust. I also had literally where it was incredibly frustrating, but like you say, nowadays they do call on these documents more. But in the past, we would do financial statements for the clients, we would sign off, we would submit, and 2 years later, no word of a lie, the person would go, oh, but hold on, why is this Margate property still in the trust? I sold it 2 years ago. Now, we, from our side, didn't pick up that it was sold because it was maybe a holiday home. There was no rental income, there was no expenses claimed against it, so it was purely just an asset in the trust. And because we are not notified that this property has been sold, there's been no resolution passed to sell this property. It's never been removed out of the trust, but now it's 2 years down the line. And all of a sudden, there's a capital gains implication that you now need to bring into the trust. And there's now penalties and interest on this capital gains that wasn't declared in advance. So things like that is what we would catch up after the fact, because no resolution was passed. And I could never understand how a conveyance attorney could sell that property without the necessary resolutions. But in later years, we did pick up that attorneys would no longer transfer properties without the necessary resolutions. But yeah, it's things like that, why those resolutions are so important, and the minutes as well, every year of meetings.
Yeah, awesome. And these are all, like, I love hearing all these stories, because it's like, it's reality. It's not something that we're dreaming up. These are things from real life cases that all of us have gotten to have to deal with over our years, and working with clients that's got trust, etc. So Wynand, I want to jump back a little bit to you about the insurance, because there are pros and cons to having insurance in the name of the trust. Can we start with a little bit of the pros? I mean, why would you do it? Why is it a good idea to take out that insurance in the name of a trust?
So Francois, there's a number of reasons why it could be a good idea. So first of all, if you have a competent team of trustees on board that you feel would be able to care for your assets and financial assets, monies, and claims payouts, especially a life assurance payout, if you feel that team of trustees would be better equipped to make decisions regarding that money for the benefit of your beneficiaries, who could be your spouse, your children, etc., then that's a pretty good idea. There are some potential tax or estate duty issues that one needs to look at, but that's on a case-by-case basis. In other words, depending on what your estate looks like, the need for changing policies to trust or the other way around could be different. We also look at, we've previously spoken about the bulk benefits. So, for example, disability, severe illness cover, which is often, in the millions that it pays out. Now, if that money pays out to you personally in your personal bank account, that's fine. You can use it to buy a nice wheelchair or to make the lifestyle changes that you need to make. But if it's an amount of money that remains in your estate and you pass away, that becomes a dutiable asset. That becomes money that you might pay estate duty on, depending on how your estate is set up. However, if you have used the trust as an owner of your insurance policy and you become disabled or you have a severe illness claim, that money is immediately paid into the trust account to be taken care of by the trustees. And it may be for your benefit also if you're a beneficiary of the trust. And I just want to, state that getting benefits, especially bigger benefits like money, property, etc., to change that ownership from yourself to the trust is almost like planting a tree or transplanting a tree. Transplanting a big tree is a lot harder than transplanting a small tree. So the more valuable the asset that you want to transfer, if you're sitting with a 10 million rand disability payment in your bank account or money, and you want to change that into the trust hands, that's either a 10 million rand loan or a donation, which has its own issues. The loan is still in your estate or the donation is still taxed at 20% above a certain limit. Whereas if those benefits pay to the trust directly, there's no loan account, there's no donation, there's nothing. There's just 10 million rand in the trust. So that's a very powerful benefit. It doesn't mean that it's meant for everyone, but that is certainly something worth considering, especially if that money is meant to serve the beneficiaries at large and not just yourself necessarily.
Yeah, and just before I get to my second part, that question is, if you want to ask any questions, please, you're welcome in the comments. I see there is a couple of questions. We'll get to them in a second. But Wynand, what are the cons, of that as well? Because obviously there's always the yin and the yang and the both sides of the coin and that kind of stuff. So those are the benefits. That's things that could work for you if it's relevant to you and if it's feasible. But what about the other side of that coin?
So I think it's not just about setting up a trust and sticking a policy in there. I think if that's the total game plan, then we need to do a bit more homework. We have to assess each individual circumstances on their own merit, and that trust structure, whether they have that or not, is dependent on their picture at large. Whether their life assurance policies, 1, 2, or all of them, or nothing gets moved into trust or not, is a decision that has to be taken on an ad hoc basis with each client. What we've seen, where things can go wrong, where policies are held in trust, one of the most obvious issues is that if you, for instance, have a very large life policy and that amount of money pays into the trust, that is a deemed asset in your estate, which is estate dutiable. So there's a scale of estate duty. If you happen to have a spouse who is money savvy and they could take care of this money and might end up using this money for living expenses for the next number of years, it might make sense to either, bequeath that money or, make that person a beneficiary on the policy. You could also split beneficiaries. So a trust could own a policy with a certain amount payable to the trust and a certain amount to a spouse. So that could cause you to save a bit on estate duty. Where we've seen things go wrong is where inevitably clients don't, they sign up for these trusts or they create them and they get this beautiful deed and they throw it in the cupboard or they take out a policy and they never attend to it any further. So we've had a number of instances where there were claims, and the moment we say to the client, yes, we are very sorry to hear about your circumstances, we'd love to help you with this claim, please can you get us the deed of the trust, the authority letter, the FICA for all the trustees, and so forth and so on, and the bank account, and they, have this funny look, and that this is going to be a mission. And it's not that it's not a valid claim, and it's not that the insurer doesn't want to pay. They're actually very good. All of them are great. It's just those sort of compliance hurdles that we need to cross. And what we found is that where clients take the trust structure seriously and they've set them up for the right reasons and they've allocated money towards carrying the cost of maintaining that structure, then things are quite easy. So we know who the independent trustees are, we know who the accountants are, we can talk to each other, get everything done, and before you know it, things have happened.
Good stuff. So let me look at some questions that we've got here. Let me just bring everybody up on the screen, and then we will do that. Okay, so let me just see. We don't have many questions. If you have any questions, you're welcome to ask them. We do have a number of financial advisors in the house. We said hello to. I'm not sure how to pronounce your name. Is it Katia? I'm not sure. Or Katja? I'm not sure. I'm sorry if I get your name wrong, but good morning. Welcome. Nice to have you here. Arun, nice to have you here as well. I just wanted to show that Terence is saying, Wynand, dressed up, impressed, #impressed nogal. Malcolm Siva Balwe is here. Good morning. Siva Balwe is asking, please discuss the impact of the loan account when transferring assets into a trust. So Renata, I'm going to pass that one to you, but I think we need to keep that answer like high level because there's a lot of implications. But just maybe, how does this loan come about, and then what are the main things that one would need to consider with such a loan?
Okay, so I'll use the asset as, for instance, a property. Let's say I have a townhouse where I get rental income and I want to put that in the trust for protection. You would need your valuation on that property, and let's say the valuation is 700,000. When you then sell that asset over, you would create a loan account, because if you're going to donate it, you're going to create a donations tax. The trust now owes you that money. So as far as creditors are concerned, that is an asset in your estate. So it can be attached by creditors. Should you pass away, the 700,000 would form part of your deceased estate and could be called up by the executor of the estate. And then, of course, also you could trigger 7C on that. And I'm not going to get into too much depth on 7C, but suffice to say that you'll end up paying a tax on having that loan account. And the only way to reduce that loan account is for the trust to, in actual fact, repay that loan account, be it in a lump sum or be it in monthly payments, annual payments, however that works. But if you, for instance, have a rental income in that trust, you've paid your relevant expenses, and let's say there's a 5,000 Rand a month profit between the income and the expenses on that trust. The only way that you're going to reduce the loan account, if you want to use that money, is to first pay the income tax in the trust on that amount. Because if you wish to pay a lower tax and you distribute that money as a distribution to the beneficiary for a lower tax rate, then that's not a repayment of loan. So the impact is that, yes, it is available to creditors if you have creditors. If you have a divorce and you are married community of property, or you are married with accrual system, it forms part of that. If you pass away, like I said, it will form part of your estate, and it could trigger taxes. So I hope I've answered that sufficiently.
Yes. So, and also just to refer back to where the 7C comes into play if that's an interest-free loan or you charge very little interest on that loan. That's usually where it comes in. And if it's a natural person that is connected to the trust, or sometimes even via a company, that would be. So we don't want to get into that, but it's that is usually when that would come about. And also, I mean, there's so many other implications that can have if something is seen as a donation to the trust, and instead of a loan and things like that. Then it becomes quite interesting how the taxman views that. So I think the main takeaways there, if I can summarize what you said, Renata, is that loan amount. So let's just say that, as you said, 700,000. That 700,000 actually remains as an asset in your estate, but the growth on that asset that you've transferred will now happen outside of your estate. So at least you've frozen that amount in your own estate for now, but it does leave you open still to, because if that's an asset, part of divorce or creditors or whatever the case may be there. So I think that was well answered. So that is good.
I just want to say one thing before we move on. The nice thing about that, let's say you have that 700,000, you now have creditors that come after you. You could maybe be in a position, if that property has increased in value, if you were able to secure funding in the trust, or you were able to increase your bond in that trust, and you can actually get some money. Let's say a creditor has a claim of 300,000 against you. Where previously they may have attached the property, sold it on auction to settle their debt, you now actually have a bit more leeway where you could maybe secure funding and then settle the debt that way. So you could have the trust repay the 300,000 to you, and you can settle the debt where you have the surety. So it does give you a bit more protection and a bit more wiggle room. I just wanted to state that. Thanks.
Okay. No, awesome. Thank you for adding that. Malcolm is asking, is it possible to buy a property in the name of the trust and have the mortgage on same property in the name of the individual?
Okay, so how it would work is if you did buy a property in the trust, it gets registered in the name of the trust. The finance, so the bond, would have to be in the name of the trust. So what would happen is the trustees would approach the bank and do all the applications for a bond. The bond will be then approved in the trust. The trust is responsible for the payment of that bond, but the trustees would sign surety for that bond, and the bond would still be, if the trust does not have its own income on a monthly basis, the bank would take into account the income of the trustees who are signing surety to secure the bond. Normally, this excludes the independent trustee, so that's important to take into account. So yes, the property would be purchased in the name of the trust, and the bond would also be in the name of the trust. One thing I have seen in practice over the last number of years is where individuals may be able to secure a 90% bond, between a 90 and 100% bond, depending on your standing. In trusts, the best bonds I saw up to 2 years ago was literally a 20%, 80% bond. So you would have to put down a 20% deposit. And for many people that think that they only needed a 10% deposit, because that's how it works for individuals, they would then have a problem. They would not be able to purchase that property in the trust because they may not have the 20% available to put down as a deposit.
Yeah. All right. Then Malcolm also asked another very interesting question, which I haven't thought of. So I've got my own opinion, but I'm going to leave it to you to answer, Renate, first. And then I will either shut up or I will also add my 2 cents. But here's the question, all right? So what is the implication of holding and buying and selling of cryptocurrencies and shares in the trust? So let's just break that up between cryptocurrencies and shares. Okay, so what is the implication of holding? So let's first look at holding shares and then buying and selling shares in the trust. Let's start there because this is a multifaceted question. Well done, Malcolm. You almost got me there, but I see you.
So I think, let's start with the shares because that's the easier one. So if I hold shares in my trust and the purpose is for it to remain there long term, obviously I would receive my dividends from those shares. And if it was true dividends, then the dividends tax would have been taken care of. And what I receive in my trust is then no further taxes unless it is REIT income. So if you've got any of the REIT shares, then those dividends are actually deemed as taxable income and you would pay income tax on that. Should you then at a later stage dispose of those shares, then you would be liable for capital gains tax. When you look at buying and selling of shares, and the whole purpose is buying and selling, then to my knowledge and my experience, you are then taxed on income tax. So where you have a gain, those are then taxed at income tax, but there would also be certain things that you would need to look at, how long you held it, but what also was the primary intention. You may have bought shares with the intention to hold it and then be forced to sell it. Then that may still be deemed as a capital gains tax. But if your intention was from the start to be a trader in shares, then you're looking at income tax. And then you also have different types of deductions that may or may not be allowed. So the fees that you would pay on those shares. So that is my answer on shares. Francois, what do you want to add on shares?
Yes, so I just want to add that, so maybe ask you a further question on that. So obviously, number one, if the trust owns the shares, then those gains or those incomes, those profits are that of the trust. But the trustees can then decide in that same year that it was earned to distribute it to the different beneficiaries. And in that way, they can mitigate some of the trust stuff. But there's a whole host of other things that goes before that, I know, that may deem it to be someone else to be liable. But let's just say everything is kosher and that and those distributions. So it's not to say that the trust will necessarily pay the tax. It could be the beneficiaries or one or some of the beneficiaries to pay the taxes on those gains or those incomes earned from the shares.
100%, unless, like you say, if the attribution rule kicks in. So if Wynand and I were doing business, and Wynand had gotten me into a share portfolio, for argument's sake, and at the time it's under 100,000, and I decide to donate those shares to the trust. We do a change of ownership, and now my shares are in the trust. If at a later stage I then want to dispose of those shares, and now it's gone up to 150, that gain would attribute straight back to me. But if it wasn't, if it was from onset with money from the trust, we purchased those shares, then yes, we could distribute the gains to the beneficiaries and declare it in their income tax. And again, we would need the resolutions and the acceptance note from the beneficiary to say, I accept and I will declare this in my personal income tax. Yes,
Yeah,
so
awesome.
great.
Okay, great stuff. So on to part 2 of Malcolm's conundrum of what he's asking us. So now we say, well, it's cryptocurrency. So my first question to you is, well, because a trust is not allowed to hold foreign assets, so are cryptocurrencies seen as foreign assets, or are they seen as South African assets? So can a trust hold cryptocurrencies? That's my first question.
So that would be, I think, very debatable. Yes. So in certain instances, trust can hold foreign assets, but the problem is then you need to open that trust up to the Reserve Bank. And that's not necessarily where you want to go. And there's a lot of hoops to jump through, so you don't want to go there. Also, at the end of the day, when you look at cryptocurrency, what is it other than a password? So in your trust, who would have that password? Who would be the person responsible for that cryptocurrency? And that would be, for me, a concern to look at. And then there's also been a lot of to and fro as far as taxes are concerned, and you may be able to answer us better there, Francois, but from my understanding, the trading on crypto would not be deemed as a capital gain, but as an income. I may be incorrect there, so that's going to be open to you. So for me, the question is, yes, where is that crypto held, and is it to the benefit of the beneficiaries? How is it to the benefit of the beneficiaries? With it being as volatile as it is. Personally, in my years of dealing with trusts, we certainly never had any trusts that held cryptocurrency. And I think that would also become a legal matter of who is really the owner of that cryptocurrency. Isn't it the person with the password on that crypto? What's your view on that, Francois?
Yeah, I don't know. So for me, it goes back to exactly what you've said about shares. So it's about the intent. And we know that cryptocurrencies are not defined as cash. So even if you transact with it like it was actually intended to be, in that case, it's not defined as cash, so it won't go through as money. So it is seen either, and they definitely look at your intent and your behavior. So again, if you are buying and selling, so we've got a client that does arbitrage, and he keeps on circling the same money, buying and selling on one exchange, or buying on one and selling on another exchange, making a profit, and keeps on doing that. So he declares that as income, because that's exactly what it is. It's speculation. It is doing it for profit. That's the game. So it's the same as you buy a property and you hold it and you rent it out so you can earn rental income, but it was an investment intent. So when you sell that property will be subject to capital gains tax. The same thing with cryptocurrencies. If you are deciding that you're going to buy and sell houses for a living, and now you make this profit every time, now it becomes trade. So it's normal income, it's normal gross income, and it'll be taxable as such. So exactly the same with cryptocurrencies. And I know SARS has come out finally last year with some views on, I think it was last year, with some views around cryptocurrencies. And I think that is sort of the gist of it. So they will treat it like shares almost. And look at your intent and your behavior from that point of view. My biggest concern was, how are these assets seen? Because you do have a South African exchange, and then you do have offshore. Does it then matter where you bought this? Will a trust be allowed to hold cryptocurrencies? Does this come down to the trustee to say you are allowed to purchase cryptocurrencies? And I guess we're waiting for the first court case on something like this.
That's what I would say. Like I say, since 2001 till last year, I have not ever seen crypto in trust. And certainly I have never, and I have reviewed thousands and thousands of trust deeds. I've never seen a trust deed make provision for crypto, and it could be because crypto is a relatively new thing. I don't know how long it's been going for, maybe 5 years, give or take. So yes, in my personal view, I've never seen a trust deed that made provision for it. That does not, however, mean that it will never and can never. This would be, in my case, like you say, we would have to see what comes out of the first court case, and maybe to get legal opinion before we even apply accounting principles, because as you say, the accounting principles would be related to intent. But what is the legal stance on this? And that question I can't yet answer, but it would be interesting to actually research and get an answer for the next time.
Yeah, no, definitely. Guys, yeah, I think that is, we've really covered a lot of ground today. So thank you very much for that. It's almost an hour. Wow. It was when I looked the last time we were at 40 minutes. Now we're at 56. Wow. Okay. So just from my side, Ida, thank you very much for being here. Again, you're my right-hand woman. Thank you very much for being here and for making sure that that we can help to answer the people. Wynand, to you as well. Thank you very much. I look forward to having you back in the future. And Renate, the same to you. Thank you very much. You brought a lot of value to this conversation today. Guys, obviously, if you need any help with these kind of things, you can get in contact with us. I will show you Ida's email address on the screen, and through her, we can put you in touch with whoever you need to get in touch with. And so particularly on the accounting side, if you have clients that need help and you want to refer them on to us, you're more than welcome to do that. Or if yourself need help with your trusts. So we do offer a trust audit or compliance audit service. And then also the accounting that goes with that and all of it. And if you need any help, with any of the aspects that we spoke about today, then please just let us know. You can contact Ida at accountables.co.za, and she will put you in touch if she's not the person to help you. But you're more than welcome to do that. So guys, from me, thank you very much. I hope you have a lovely week further, and I will see you back next week, same time, same place.
Bye.
Bye, everyone.